may be seated.
Okay, last case on the docket, Mary Rogers versus BHOWANI and JAIRAM. Screen, whenever you're ready to proceed.
Thank you, Your Honor. May it please the Court, I'm Barbara Green. I represent the plaintiff, the appellant Mary Rogers. I'd like to reserve 5 minutes for rebuttal. The jury found the drunk driver in this case only 25% at fault and awarded only minimal past economic damages. And it's our position that this was due to 3 categories of errors by the trial court that all played into each other. The court has expressed special interest today in the misconduct of defense counsel, and so I'm going to address that first. Defense counsel's misconduct in this case was so egregious and so pervasive that he admitted in his response to the motion for new trial that plaintiff's counsel had to wear a path in the rug from what he called his frequent sprints to the bench to voice his objections.
Let me ask you, was the first issue that you raised is the use of props, and I didn't see any objection to the use of the props.
The one that was objected to was during, prior to and during Dr. Lichtblau's testimony. He had his daughter, who he kept referencing as his daughter, wheel out a hand truck with 2 banker's boxes full of notebooks. And this was described in the record by the trial court. It's a hand truck with 2 banker's boxes full of notebooks. Plaintiff objected that this was a display or a show unless it was going to be used as impeachment. The objection was overruled. Counsel assured the court it was going to be used as impeachment. And then in his beginning of cross-examination of Dr. Lichtblau, he warned Dr. Lichtblau that he had investigated Dr. Lichtblau's testimonial background, and plaintiff objected there as well, and that objection also was overruled.
Now, I thought that the boxes were brought in while the jury was out, and that the court instructed defense to move the boxes, which was...
But they were there. They were there. The record, I believe, reflects that they're there the whole time, and all the court did...
There, meaning at counsel table?
At the podium. And all that the... At
the podium from where the lawyer was questioning.
That's correct, Your Honor.
Right,
and all the court did was instruct
if your
to move away from the
volume of
jury.
notes is too large, then that's a problem?
He never used them. He never had any intent to use them. He never used any of them. He never opened a box. And at the end of Dr. Lichtblau's testimony, plaintiff's counsel pointed that out and renewed the objection. And the court said, you know, the objections were overruled.
All right, so there's a box at the podium from where the questioning is occurring.
It's 2 boxes.
Okay. If it's 6 boxes.
And a hand truck.
You know, and they're all stacked up, so what?
Well, because he says, you know, I've really thoroughly investigated you, Dr. Lichtblau. Like, don't you dare, you know, lie to this jury. In other words, that's the implication. And then he never uses a one of them. He never cross-examines him with any of it. So there's no purpose to it except to put on the show.
When I tried cases, I had, you know, notebooks full of stuff ready because I knew what the answer was going to be, and if it wasn't, I knew exactly where to open the transcript to impeach with a prior and consistent statement. I mean, I just don't, I mean, that's normally the way you would prepare for cross-examination.
Yes, and I bring materials to Your Honor. I've got a file and I've got a briefcase, but you have to read it in the context, and the context is that that he basically threatened Dr. Lichtblau with it. It's not just the isolated act of having those there. It's threatening Dr. Lichtblau with it. Testifying essentially to the jury, and that's an objection that was raised.
If you're at counsel table and you have the banker boxes behind you, you know, as described, you know, and you say, well, you know, all right, let's, you know, we're going to begin our cross-examination. You know, we're ready for you. You know, is it Because it's present at the podium as opposed to behind counsel table?
It's because it's present at the podium, and it's because of what Your Honor has characterized as, we're ready for you. He said that. He testified to that. He told the jury, we've investigated you, Dr. Lichtblau. We have vetted you. And I think that's what makes the difference.
And that is, so that gives you a new trial?
Not by itself, but that's one preserved objection, and it has to be read in the context of the whole trial. He then, in closing argument, and these are not preserved, but they're part of the context, he deliberately mispronounced Dr. Lichtblau's name in a rather juvenile way. He described him as resembling Alfred E. Newman. He called him the Costco of experts.
And I can tell you that you know, and that I'm conflicted with these because there are two separate principles at work. One is that we're just seeing some closing arguments that just are wrong. They're improper, they're unprofessional. On the other hand, there aren't objections.
Well, there were objections here, and there were objections to those. It's just there wasn't a motion for mistrial made. So what those become, it's not like there's a calculated decision to let those things slide, which is, I think, the kind of thing that the court is concerned about when there isn't an objection. Here there were so many objections that defense counsel actually bragged in his response to post-trial motions about how many objections he made defense counsel make. And that in itself is prejudicial.
Or in the brief, they kind of say they were isolated incidents, don't they?
Well, he says they're isolated in the brief. But that's certainly not what he said in his memo. He said, I've been practicing for however many years, and I've never seen so many objections. He wore a path in the rug. It was unprofessional for him to object so many times. And that's the kind of impression that having to object that many times gives a jury, is that plaintiff's counsel is being unprofessional, or plaintiff's counsel's trying to hide something, which kind of plays into the little show that he put on with Dr. Lichtblau with the boxes, that plaintiff's counsel was trying, or plaintiff's expert was trying to hide something from the jury. And the first district observed that in Botcher, that when a plaintiff's lawyer complies with Murphy, as plaintiff's counsel tried to do in this case, what happens is it alienates the jury, and it makes the jury think he's objecting so much, there must be something really important here that he's trying to hide from us. And that's the kind of thing that this whole strategy is designed to do. So then you've got him in closing argument denigrating plaintiff's counsel and plaintiff's hiring of counsel. He says plaintiff hired counsel when the ink was not dry on the triage records, and that's why I don't allow my clients to apologize or make statements, because it's
Wasn't that in response to your client's counsel below chastising the defendant for not apologizing, calling it dishonest, offensive, and there were some, pretty, I mean, there were arguments that...
But those arguments are not inappropriate, Your Honor, in a case where punitive damages are at issue. When a jury's considering whether to punish someone in addition to awarding compensatory damages, when the jury's considering that, the jury has to consider whether the defendant is remorseful. So it was perfectly proper for plaintiff's counsel to point out he's not remorseful, and he's not expressing that he's sorry. He's not apologizing. So to denigrate plaintiff's counsel and plaintiff for hiring counsel and insinuating that they're going to do something wrong if the defendant did apologize, that is in no way justified by plaintiff's counsel pointing out the defendant's lack of remorse. because that's an appropriate factor when punitive damages are an issue. Now, this was aggravated further, and again, we have to talk about context, because this particular one, there wasn't an objection, but the similar objection had already been overruled. He argued to the jury, you don't know the history and there are reasons why apologies don't occur. It's the same argument that the objection was just overruled to, so it would have been a futile act to object to that.
But I'm still struggling with, okay, so it's proper to say it's outrageous, he never apologized, he's horrible, to come back and say they had a lawyer from the beginning, you can't infer anything from that. I mean, I don't know why that's not a fair response to that argument.
I don't think that is a fair argument when he says that she had a lawyer 2 days and there's reasons and you don't know what they are. That's basically the lawyer testifying that there's stuff that the jury doesn't know. It's telling the jury there's stuff they don't know, which again plays into the whole thing of there's stuff you don't know and it's being concealed from you because plaintiff had a lawyer. So that's part of the same theme of concealing things from the jury, and that's an improper theme. And it's designed to make the jury...
So maybe that particular statement was an artful argument, and there is a proper argument, but I guess that goes to the whole Murphy thing. If there had been an objection, a curative instruction, then that could have been...
Well, there was an objection. There was an objection, but it was overruled.
Not to that statement.
Pardon me?
Not to that statement.
To the second statement, no, there was not. But to the first statement, that's why I don't allow my clients to make statements. There absolutely was an objection to that. And that's, a lawyer giving improper testimony about, advice that he's giving his clients. That's not proper for a jury to consider. It's not proper for him to tell the jury, I think plaintiff's counsel is going to do something wrong, so I tell my client not to apologize. There's no way that's a proper response, Your Honor. And then the third major theme, and this again plays into the issue of the plaintiff having some kind of secret information that they're withholding from the jury, is the repeated comment 3 times on the plaintiff's failure to call witnesses that were available to both sides. These were the treating doctors, and specifically mentioned was the treating surgeon. He said, I have a list of the treating doctor, of the people that plaintiff didn't call. They didn't call the treating doctors. They particularly didn't call the surgeon. And plaintiff objects, makes a motion for mistrial. The court sustains the objection, denies the motion for mistrial, and gives a curative instruction. The very next thing out of defense counsel's mouth is, the very surgeon who performed the surgery did not testify. Again, there's an objection and a motion for mistrial. The objection sustained, the motion for mistrial is denied, and the court denies curative instruction at that point, saying, I think it's covered. Well, if it was covered, how come defense counsel didn't understand that he wasn't supposed to do that? And then just a few pages later, he does the same thing again. They won't bring the real doctors who treated the plaintiff. There's an objection.
You understand that
the court gives the curative instruction.
When you do your brief, that and I'm looking at your 3 issues framed in your brief, that you don't frame that as one of the issues.
I'm sorry?
You don't frame that as one of the issues. There are 3 issues. The trial court erred in allowing Trooper Velez to give his opinion in reference to the impact and the speed, improper factual basis. The second point on appeal, trial court erred in allowing the defense CME to give misleading prejudicial testimony about refusal to answer questions. And the third was the defense counsel's use of props, reference to other matters, not the evidence, and personal attacks. Those are the 3 issues that you framed on your issues for your arguments on appeal.
Yes, and the third one is a cumulative error argument, and in that argument, I do say that you have to consider it in the context of the whole trial. And I do say in that argument that it has to be considered in the context of all the other issues, I believe, that make the jury think that the plaintiff is hiding something. And so I respectfully disagree, Your Honor. That was certainly my intent, and I do argue that this harmed the plaintiff cumulatively on liability and on damages. I see that my time is almost up. I'd like to reserve the rest for rebuttal.
Good morning. May it please the Court, Dennis O'Connor for the appellees in this matter. And as Your Honors know, I don't come here very often, but I deliberately came today because if there is music to be heard, I need to hear it. And because I did try the case below, I wanted to be able to respond to the questions. And
Right, when you tell the jury that there are reasons, that there are things that you don't know about, aren't you effectively testifying?
No, Your Honor, respectfully. And are you referring to the colloquy with Dr. McBride about the invited?
Well, I think this was on.
In closing argument.
Argument where you say, I think you said something like, look, I've had conversations, you don't know what's going on, I've had, I've had conversations with these lawyers for over 2 years, and you don't know what's going on, kind of thing. I think it was a response to, it may have been a response to, he never apologized. I don't know.
I think, right, in that.
But I mean, it seemed to me like, gee whiz, I mean, what's that about?
It was a reaction and a response to the suggestion.
Well, I know it's a reaction and a response, and what I'm asking you is, do you think that was proper?
I think under the circumstances that statement was proper because I'm defending the fact that my client never apologized, and I was explaining why.
Oh, there are things you don't know about. You got to take my word for it.
Well, that may have been.
Just trust me.
I mean, that's
Well, no, that's an unfortunate, and when I hear you tell me that, that is an unfortunate use of words, and so I would agree with you, Judge.
I'd like to go back to the Dr. McBride thing. Now, you say
Right.
it's about, now, you all had an agreement, correct?
We did, Your Honor, yes, right.
But she didn't have to fill out his form and didn't have to give him a history.
True.
So, he kind of gets into it on cross-examination, but then on redirect, the first thing you said was, or I mean, not been the first, but, Mrs. Rogers failed to give you a history. Now, you knew there was an agreement.
Which, on direct examination, that's true.
You came back and you said, and he says, yeah, why would you say that?
Because
I mean, there's an agreement.
On cross-examination, the theme was this doctor had an incomplete.
But he was, exactly. I mean, but and the doc kind of said, well, she wouldn't tell me, and, but you knew there was, then he wants the curative instruction.
Right.
And the one he had seemed to make sense to me. Why not just say, look, the lawyers had an agreement that she didn't have to do it. The way they left it was like it was kind of up to her whether she wanted to or not. I mean, It just didn't seem, and you said, and I don't blame you, you said, well, look, don't give the one about the agreement because I asked the question and they're going to know I knew there was an agreement. I mean, that's what kind of was your argument.
Right.
Which isn't bad, but honest to God, that's what we should have heard, I think.
Right. I thought the door had been open, and I apologize for that. I thought the door had been opened by reason of the cross-examination question.
Not really. I mean, the doc kind of interjected, he wanted to be an advocate a little bit,
Right.
But the first, when there's the agreement and to say, what, she didn't give you a history? And, well, no, And then, of course, he volunteers like, I'm a little suspicious or whatever he said about it.
Right. Judge, there were, Judge Jacobus, 6 or 7 doctors who testified live.
Yeah.
A number who talked about her back. See, there's a back issue and a neck issue. Dr. McBride addressed the back. Dr. Flynn's records were in evidence, and yes, he did not testify. And there was evidence of prior back problems. There was extensive medical...
I mean, as a trial judge, and we all were trial judges, I always thought it was up to, the defense, or their CME guy, to give them all the background, that, all the histories you wanted to consider.
No, what we're talking about is an oral
I
explanation.
understand. I know
All the records were
exactly.
supplied. Right.
Yeah, But
Right,
I mean, I guess the thing that was troubling to me was that, there was an agreement, you knew there was an agreement, and then to ask that question, I mean.
Right.
And, I mean, it's obviously, I've known you a long time, you're a smart guy.
Right.
You thought, well, geez, if he gives that instruction as curative, they're gonna think kind of.
Regrettable, if I could offer defense of old age. In my defense, the agreement it was an oral agreement with Brian Wilson, and it was entered into.
But I mean, we know.
There's no excuse for it.
I mean,
Right.
you all make those agreements all the time.
Sure,
I mean, that's
absolutely.
Nothing uncommon about it.
Yeah, it was not a calculated, and if it was harmful, if it was improper, it was not harmful in light of the totality, the
It
medical.
sounds like she's hedging. She wouldn't tell the doc, what happened in the accident. She didn't want to cooperate with him or anything. I mean, I don't know. I mean, it just seemed
Right.
bad to me. I mean,
The history is lifted, though.
I think the instruction, that was suggested by the plaintiff, had that been given, it would have cured it. I mean, that there wasn't. I mean, that's all you had to do was say there was an agreement between the lawyers that she didn't have to do it. Boom, end of deal.
True.
And
I
then
forget
they
the.
took out that part and said, well, she just didn't have to do it. Kind of.
Well, Judge Fleming must have thought the curative instruction that he
Well,
gave was.
I mean, you argued the thing about, well, Judge, I'm the one that told him, and if I mean, I asked the question,
Right.
I knew there was an agreement, the jury's going to be mad at me for doing that,
Right.
He kind of bought into that.
There's a double-edged. There's also some. I mean, it's sometimes you do things double. There are two sides to these decisions.
Oh, yeah.
I mean, on our feet,
I understand.
without the benefit, did not expect there to be questions about the incompleteness of the history that he
Right,
obtained.
yeah.
But can I touch?
I think, he was talking about the other histories from the records and
Right,
stuff,
right.
not what she told them.
Right. Again, days of medical testimony, pages and volumes of medical records.
Yeah.
The causation piece was litigated extensively and thoroughly. We had doctors addressing the neck, doctors addressing the low back. We had a physiatrist. There was an internist. If I could speak to Dr. Flynn, because counsel, who I'm meeting her for the first time, she was not present at the trial. She gives me far too much credit to say that I calculated the things that I supposedly did so badly. Dr. Flynn did not testify. However, his records were in evidence. And I will tell the court that I have heard that argument made countless times in trying cases, and I've done it a few times. And the risk with doing that, and the response that I typically draw when I do it is, well, O'Connor could have called him, and he didn't.
Right.
And I was so curious about the allegations against me that I went and purchased the ethics and oral argument, and closing argument piece, and to try to find out whether there was any guidance. And frankly, there was a question posed by the panel to the lawyers in attendance, and on that subject, and there was no consensus as to what the law really is. And I frankly am not certain I know either. And then in addition, this past week I was on the faculty of an advanced trial advocacy program at the University of Florida, and there were judges and lawyers who were there as students. My role in that was to give a closing argument for one of the defendants. And there was an ethics piece to that, and there was an ethics tutorial. And I was very interested in that, and I did run these scenarios by very experienced lawyers who were on the faculty with me, trial judges.
Yeah, are you going to give us the vote? Is that what?
No, sir,
okay.
but I just want you to know, Judge, that I was sufficiently.
Did you win?
Well, I mean, the law is, if it's equal, it seemed to me, you made that argument, and that is the counter to it, obviously.
Right.
But the judge gave the curative instruction, but it wasn't complete, I don't think. It wasn't really what he should have said, And
if it's an improper argument, it is harmless because of the totality of the evidence, the entirety of this record. That medical evidence was vetted and discussed and presented.
Let me ask you this.
Yes.
What did the trooper say about the speed? What was that? I'm rather.
He said that he thinks the speed exceeded the limit of 45, but he wasn't sure. And
Put 45 on the accident report.
right,
Because that was the speed limit.
yes, sir. And if you have, and I couldn't find it this was briefed by a former partner, Jerry Tolton in Tampa, and I looked for on easel I had a drawing, and I had the witnesses put the vehicles, and I filed it in the lower court. I don't know whether you have it, but I suspect on there might be some notation. He testified of a speed possibly in excess of 45 by reason of the damage to the vehicles.
He had no,
And there was no objection to that opinion.
I think there was.
Yes, sir, but I think that...
Speed?
Yes, I think this, no, well, I think the speed evidence came from the plaintiff's side of the case.
Oh, could be.
I don't think I asked him about the speed. I hope I didn't. I don't think, I'm quite certain, and I read his testimony this morning. I'm quite certain I did not ask him about the speed. I asked him about his feelings, his views, his beliefs about where the vehicles were. We have an Intrepid driven by my client, and we have a minivan. Officer Velez places the tail end of the minivan in the street for a couple of reasons. Number one, the damage profile to both cars. Number two, there are some landmarks. There was a sign, and then there was a fire hydrant right off the shoulder there, neither of which were damaged. He places a portion of the vehicle in the northbound lane of OBT. Mr. Castillo, who I think was the most important liability witness, he testified. It was all happening right in front of him. It's about midnight.
Did he say she made a U-turn?
Made a U-turn and
But so the damage is on the wrong side of the U-turn.
yes, sir, that's true. But he said in response to one question that 100% of the car was in the northbound lane, and then in response to a question on cross-examination, he said 80% of the car. And in fact, in closing argument, counsel acknowledged comparative negligence, as he tactically should have. There is the liability portion of this case, it cannot be respectfully suggested there is any irregularity. These witnesses were vigorously cross-examined. Officer Velez was called by the plaintiff, Ms. Rogers, in the case, and I cross-examined him. I of course, called Mr. Castillo. My client testified that he never veered from his northbound lane. Now, of course, he was intoxicated. He was intoxicated, and no witness testified that car ever veered from the lane he was in, and Ms. Rogers testified candidly.
There's only 3 possible people, I guess, that could say that, right?
That's right.
Your client,
right,
and then
Ms. Rogers, and
the guy.
Yes, and I think the best you can glean from Ms. Rogers' testimony is that wasn't really quite sure where she was relative to the roadway. So the liability determination, we think cannot be.
She testified in deposition that she didn't know, but then in trial she testified that she went out and looked at things, and she had determined that she in fact was out of the road. That was her testimony.
Yes, Your Honor, that's correct. And so the jury had that evidence to weigh and discuss, and they reached their verdict. They allocated responsibility, and we think that is certainly within their. What
do you think about comparing the appearance of a witness to Alfred E. Newman of Mad Magazine?
In retrospect,
you had to have a jury of a certain age to even know what that meant. But
in retrospect, Judge, I wish I had not done so. But if I could respond,
Costco of experts.
I plagiarized that from another lawyer who, and the point being that everything's so big, everything's so grand, everything's so large that it's not necessary.
If I belong to Costco, does that say anything about me?
I represent Costco.
All right, I just wondered.
I don't quite understand the Costco anyway. What does that mean?
But if I could talk about Dr. Lichtblau, the reason I did that is I never met him before. I vetted him very carefully, as I always do when I first encounter an expert witness. And yes, my daughter Katie did help me. And if I could ask one favor of you, if you have 5 minutes in your busy schedules, if you would just so much as read my response to the plaintiff's motion for new trial. I set it out because I was so provoked by the motion. I took a few days, and then I drafted this response, and it tells you, and it's verified because I was so troubled by the allegations. It's verified, and it spells it all out. So he enters the courtroom, and I've been told by one of the lawyers I spoke to that he physically resembles Alfred E. Newman, and he does. And not only does he physically resemble him, his behavior is akin. I could read to you from the record no less than 10 or 15 comments that he made.
Did he say what me worry?
He did not say what me worry, but he said if it walks like a duck, quacks like a duck, and if it's on Goo Goo Gai Pan, it's a duck. Or I studied girls at FSU, the Harvard of the South. Or
is that in response to questions, or is that?
No, I had, Judge, in my materials, he had testified to this, previously over...
you asked him all
Oh, yeah.
this?
And in these boxes, these sinister boxes, I learned how to do that from a very fine lawyer in Brevard County a long time ago who expertly cross-examined a doctor named Hoffman by doing the same thing.
Was he here today?
He was here today.
That's
And
what
after that happened 15 or 20 years ago, I commended him. I told him that was amazing. And so it streamlined. You may have been the judge on the case. It streamlined the cross-examination. I said, Doctor, look, I've investigated you. You can agree with what I'm going to tell you, or I can show you where you said it in a deposition. And he agreed with me. He turns to the jury. Mrs. Green doesn't know this. And it's folksy with the jury. And, yeah, I fly around. I testify. I do this. I did very carefully. And my daughter helped me. And this prop is one of those anatomic models. I do it all the time. But back to your point, Judge Cohen. Here's how I set this up. I'm in the middle of my closing argument. And I said to the jurors, and I'll paraphrase, I don't know how old you folks are, but if you're about my age, you might remember a magazine, Mad Magazine. And to a person, they all started nodding their head in affirmance and smiling. And that was my cue. Had I not received that reaction...
Now, but none of that's of record. And
it isn't.
You know.
No, sir, it isn't. And I said, that's who he reminded me of. And I moved on. That was the sum total of that. And it was light. It was not malicious. It was not mean-spirited. If you read it in the context, it was not a calculated...
What was the purpose?
Just to be silly, goofy. I'm an Irish guy. I was something that popped into my head. But I will say this, Judge Jacobus, the behavior of Dr. Lichtblau was at times, he was by no means a statesman. He was comical. He was a parody of himself at times. And while, yes, Judge Cohen, I regret in retrospect, and there are a lot of things in life that I regret, but it is not so pervasive. That comment, tongue firmly in cheek, was not so pervasive that this jury deliberated in a case that went a week. When you add in the dinner that was brought to them, they deliberated for an hour and a half. The evidence was so compelling, or the lack of evidence was so obvious on the medical causation part, that the jury, it took them very little time to rummage through that testimony. And so, yeah, I regret, Your Honor, I regret in retrospect doing it, but it does not meet the Murphy test. While it might be improper, the other three prongs, it didn't contaminate the case. It did nothing of the sort, Judge. It doesn't rise to the level of some of the comments that we see in the other cases that I cite in my brief. If I could put my hands on those real quick, Judge. And before I get to this, the case we cite on the ability of an officer to testify, Dragon versus Grant, in that case, the court ruled and determined that a police officer could even render opinion testimony. And the qualifications of Officer Velez were provided by the plaintiff in this case. 20 years, went to the academy, and so forth.
They said he had no Reconstruction experience, I think, didn't he?
I'm sorry?
I thought he said he didn't have any
Right,
real experience.
right. But that was one of the criticisms.
Going to
Right.
Rex a lot, you know.
Right. Judge, the Armada versus Yandell case gives us some examples of the comments that are deemed to be so fundamentally harmful that a new trial was warranted. In that case, the following comments were made. There was reference to commenting on a court's ruling on a motion in limine regarding a denial of a directed verdict, comments about the financial disparity between the plaintiffs and the defendants, improper golden rule arguments, improper expressions of personal beliefs and experiences, and improper personal attacks on defendants, counsel, and defense witnesses, which, by the way, if you look at this record, there was never so much as one personal attack. And other cases talk about injecting religion. None of that happened here. None of that happened. Did it get testy? Did it get testy after Mr. Wilson accused Dr. Powell of lying? It did. And they're friends of mine, and it got testy. And sometimes these things happen, but nothing so fundamental was said or done. And Judge Fleming, who presided over this trial, great deference needs to be respectfully provided to Judge Fleming, who presided over the trial, denied the motion for new trial, and we think deference needs to be afforded to him. And so, are there any other questions? My time is running out that I could answer at this time, please.
I don't have any. Thank you very much.
Thank you.
May it please the court. Counsel has invited the court to read his response to the motion for new trial. I would beg the court to do so. It's a remarkable document. I'm going to address just a few of the arguments he made. If he wanted to explain why his client never apologized, he should have elicited that testimony from his client. He shouldn't have tried to do it himself. If he didn't want to waive the attorney-client privilege, then he just had to let the issue go. With regard to Dr. McBride, he's apologizing now, but that doesn't affect what the jury heard. It doesn't matter if it was calculated or not, it was harmful. The seminar counsel attended is not precedent, it's not in the record. There's case law on the equal ability to call witnesses. With respect to the trooper, he elicited the testimony about speed. That's on page 122 to 123.
But there was no objection to that, correct?
Yes, Your Honor, lack of predicate.
There was, wasn't it?
Yeah, the objection was lack of predicate, 122 to 123.
No, there are a couple of cases from the 4th DCA that lack of predicate is objection sufficient to preserve any specific. I mean, the objection is really that the witness is not qualified to give an opinion. It's not.
He had no factual basis for it. It's not just his qualification, it's the lack of any factual basis.
The objection was lack of predicate. In other words, that's what.
Yes.
All right. But there's some cases that say that's not enough. In other words, that's like, I object, and don't say why. I'm not so sure that lack of predicate's not, we all use that. I mean, I'm not so certain that's.
Well, I think that's enough to tell the court that there's not enough of a factual basis for it.
It's not.
There's
All right.
a case they didn't.
And then, Your Honor, with respect to your question about whether the brief argues that the issues built on each other, and yes, they did, and the argument is discussed in the summary of argument, and throughout point 3, it talks about everything throughout.
I was simply pointing out to you that wasn't listed as a separate issue on appeal for what that was worth.
It's really part of point 3, Your Honor.
Okay.
And we would ask the court, I know Mr. O'Connor is charming. I've just met him today, and he's come here and he's shown you his seminar.
You don't feel that way about him.
Well, the court's been smiling and laughing with him, and my client is here today, and I would like my client to understand that the court does take these matters seriously, that the court is concerned with whether she got a fair trial, and that the fact that the court may be bantering with Mr. O'Connor has nothing to do with whether Ms. Rogers was prejudiced.
We banter with you as well.
Yes, Your Honor.
This is
Absolutely.
Thank you for that argument.
Thank you, Your Honor.
Thank you very
Thank you
much.
all very
Court is in
much.
recess.